Hi, I'm Anna Denton-Jones of Refreshing Law Limited, and in today's session I want to talk about a recent case of Lenlin and Kular in relation to protected conversations. What had happened in this case was that an individual had been deemed, if you like, responsible by a company for the loss of nearly £2 million whilst on his watch, if you like. They engaged a forensic accountant to come in and investigate what had gone on, and the findings of that investigator was namely a recommendation that further disciplinary investigation should be undertaken. Rather than do that, the company decided to offer the individual concerned a settlement agreement, presumably with a sum of money for him to leave and, if you like, go quietly and avoid them needing to go through that disciplinary investigation. However, when they had the protected conversation with him, they gave him a week to come back to them with a signed agreement, and they presented it to him as if the investigation that had been done by that forensic accountant had actually recommended disciplinary action and concluded that there was gross misconduct or gross negligence involved. The individual didn't take the package. Unusually, he challenged what was going on and resigned and brought claim of constructive dismissal. So one of the things that occurs in the tribunal is an argument about whether or not what had gone on in that protected conversation was admissible evidence or not. And you'll be aware that the whole purpose of Section 111A of the Employment Rights Act is to create the ability for employers to have these genuinely off-the-record conversations with somebody, and that ordinarily that conversation is not admissible in an unfair dismissal hearing. Now, you're probably aware that the ACAS guidance around settlement agreements suggests a 10-day period between offering the settlement agreement in a protected conversation and setting any deadline for the employee to come back to you. Now, I've always viewed that as just guidance, as the word suggests, and that it wasn't a particularly legally binding thing. And perhaps there are circumstances where putting a little bit of pressure on somebody to come back to you quickly might not be a bad thing. However, we now need to review that practice following this case, because the Employment Appeal Tribunal was very critical of the employer only giving this person 7 days to finalise the whole thing, and specifically referred to the ACAS code and were of the view that that guidance should have been followed. So I would now view that guidance as far more mandatory than perhaps I did before. The other big issue, of course, was the fact that the employer had misrepresented the report and what they had on the individual, if you like, and that was viewed as part of the improper conduct of the employer. So it's very important that we don't over-egg any evidence that we have, and that we're very careful about how we present perhaps disciplinary as a foregone conclusion, if you like. What you need to be doing much more, I think, is if you are choosing to have a protected conversation prior to going into the disciplinary process, it needs to be done in a manner where you're explaining to the individual that you are quite happy to go through that disciplinary process, and you are just offering this to them as an option, as an alternative route should they want to go down that road instead, rather than making it appear that you're very keen for that to happen. So there's a certain amount of smoke and mirrors to engage here. But the upshot of this case is that we do need to be very careful about how we write any letters sending settlement agreements out, that's something I can certainly help you with if that would be of further interest. Please do email me, adenton@refreshinglawltd.co.uk if you've got any questions. Thank you very much.